What is constructive discharge or forced resignation in Florida? Being pushed out of a job you've worked hard for is both frustrating and demoralizing, especially when the reasons are unlawful. In Florida, some employees find the workplace so unbearable that quitting seems like the only option. This situation, being compelled to leave because of intolerable conditions, is called constructive discharge. Under Florida law, constructive discharge occurs when an employer makes working conditions so intolerable that a reasonable person would feel compelled to quit. Although you hand in a resignation letter, the law treats your departure as a firing when the conditions were both intolerable and unlawful. Simple dissatisfaction isn't enough. There must be extreme, ongoing conduct that violates state or federal employment laws. Discrimination or retaliation based on race, sex, pregnancy, national origin, age, disability or marital status can make conditions illegal. If you are unsure whether your circumstances meet this standard, speaking with a Florida employment lawyer can help you evaluate the facts and protect your rights. Florida courts treat constructive discharge like being fired because the resignation is not truly voluntary. The misconduct must be severe and unlawful. Persistent sexual harassment, repeated retaliation, unsafe working conditions or being excluded from opportunities may qualify, while routine unfairness does not. Courts also expect more than a single isolated incident unless it is extremely serious. To prove constructive discharge, gather evidence. Save emails, text messages and memos that reflect unlawful conduct. Keep a log of incidents with dates, times, people involved and what happened. Medical records showing stress or anxiety related to the work environment can support the claim. Statements from coworkers and past positive performance evaluations also help. Courts look at whether you reported the misconduct or used internal complaint procedures. Delays in resigning or inconsistent reasons for leaving can undermine your case. If you had to resign because of illegal and intolerable conditions, you have options. In Miami, you may file a discrimination claim with the Equal Employment Opportunity Commission. Florida's work-sharing agreement extends the deadline for filing to 300 days after the last discriminatory act. You can also file a state discrimination claim with the Florida Commission on Human Relations within 365 days. Filing with one agency often preserves rights under both systems. Even though you resigned, you may still qualify for unemployment benefits if you can show the resignation was involuntary. After completing the administrative steps, you may file a civil lawsuit to recover lost wages and emotional distress damages. Before quitting, take steps to protect yourself. Document every incident of harassment or discrimination, noting dates, times, and witnesses. Save emails, texts, and any evidence. File a written complaint with Human Resources or a supervisor, describe the unlawful conduct and request remedies. Courts consider whether you used internal procedures when evaluating a claim. Seek medical care if the stress is affecting your health. Consulting a wrongful termination lawyer or an experienced wrongful termination attorney can help you understand deadlines and strengthen your claim. Constructive discharge claims acknowledge that a resignation forced by intolerable and unlawful conduct should be treated like a firing. Understanding your rights and gathering evidence are essential. Lawyers Jason D. Berkowitz and Anisley Tarragona of BT Law Group, PLLC represent employees in constructive discharge and wrongful termination cases throughout South Florida. BT Law Group, PLLC is a law firm that focuses on employment rights, and their law firm is located at 3050 Biscayne Boulevard, STE 205, Miami, Florida, 33137, United States. They can be reached at 305-507-8506. Speaking with an attorney can help you determine your options and protect your rights.